Good morning, everybody. We'll get started. I'll keep an eye on the waiting room. Today's presentation for our KLS webinar series is on Kansas expungement law by Nick Larkin, presented by Andy Kent. And I'll let Andy introduce himself. And I'll also try to get the flyer into the chat about the upcoming clinics. So I'll
Great.
turn it over to you, Andy.
Thank you. Good morning, everyone. My name is Andy Kent. I'm an attorney with Kansas Legal Services. I've been here since 2023. Before that, I was a assistant city attorney for the city of Leawood, and then more recently, a prosecutor at the Unified Government, Wyandotte County in Kansas City, Kansas. My practice in with KLS started almost exclusively in the expungement arena, and then, as many people on this call probably understand, grants change and things change, and I'm kind of in a more generalized role, but still do quite a bit of expungements. So today we're going to talk about what expungements are, how to get them, and then sort of what the end results of those things are. And throughout, we'll talk about some of the important things to remember, and maybe some things you can share with your clients about how to reach these kinds of goals in terms of getting folks into better housing, better schooling, better jobs, that kind of a thing. I will give 100% credit to Mr. Nick Larkin, who is another staff attorney. Or no, he's not staff attorney. He's director of expungement clinics, I think. And he put this presentation together. And then they are doing a clinic today. And then, as Kayla mentioned, we'll be sharing some information, hopefully in the chat, about the clinics that are available around the state. So what is an expungement? It is the process by which we can seal up criminal records, which makes them not viewable to the public. There are a lot of entities that can still see these things. There are folks that you still have to disclose the convictions to. But for the most part, the public record, think landlords, schools, employer background checks, that kind of stuff, it will be sealed from view, which means they won't be able to see that it exists. Those applications for jobs or housing or schooling, you can say that never been convicted if you successfully get an expungement. Why do we do it? Well, the kind of answers was right there. Better housing, better jobs, better schooling. Some folks want it because it's, maybe this was a 1998 conviction, and they're not really wanting to be saddled with that for the rest of their life. The reasons underlying why you want an expungement aren't as important, perhaps, as some of the other things we'll talk about today. But it helps you understand that, when you've sealed these things up, it opens doors, it creates opportunities, which I think everybody can agree is a good thing. So what can be expunged? Expungement only applies to criminal convictions. A lot of folks may have evictions on their records or collections or garnishments, those kinds of things. We cannot use an expungement to clear those records up. Those can't be sealed unless you get a special order from the judge for sealing the cases for certain reasons, and that aren't necessarily pertinent to today's conversation. But for all intents and purposes, this is exclusively for criminal cases. Expungement means criminal cases. We can do a lot of different kinds of outcomes. So convictions, diversions, arrest records, dismissals, juvenile adjudications, anything that touches on that criminal justice system, that is available for expungement. So the first step in any expungement case is determining eligibility. There are a series of statutory factors, and then some case law things that kind of come up about how to determine whether an individual can get an expungement. It's a yes or no question. Either you qualify or you don't. There's not a lot of gray area on that question, but getting to the answer of that question, there may be some nuance in areas where a good attorney or some preparation ahead of time can really improve your chances of successfully getting an expungement. So some of the big topics are here. The first one that is a complete bar. If you are on any Kansas offender registry, and we'll talk about that more in the next slides, you cannot get an expungement of any conviction, regardless of whether or not it was the conviction for which you are on the registry. Can't have any pending charges, no felony convictions in the last 2 years, only expungible offenses. The whole case, only expungible offenses. And we'll talk again more about each of these things in more detail. There's waiting periods, no outstanding fines and fees. The two that probably where the lawyers earn their most money, if you will, is the circumstances and behavior and expungement consistent with the public welfare. Now, those are pretty gray. There's no actual statutory factors or anything like that, but we'll talk more about all these different things as we go through. Just wanted to give you kind of a roadmap. If you are on an offender registry, and Kansas has three of them, the sex, violent, and drug offender registries. If you're on any one of those registries, you cannot receive an expungement for any conviction in the state. There are some pathways off, and well, only for drug offenses, but there is a pathway to get off that drug offender registry a little early, which we'll talk about in a slide in the future. If you're required to register, though, just know not eligible for expungement on anything. Even if the case is 40 years old and has nothing to do with what you're registering for, if you have to register, you can't expunge anything. So the no pending felonies or felony convictions in the last 2 years, the statute can be a little bit ambiguous, and occasionally there will be county attorneys who maybe think that even a misdemeanor is a complete bar. But really, the statute talks about felonies. And if you've got a felony in the last 2 years, or if you're in the process of a pending felony, um, and we say currently on paper is sort of a thing that a lot of folks who are unfortunately familiar with the criminal justice system are familiar with that term. If you're on probation, parole, anything like that, you are not eligible for expungement until that time period is over and you are released from the parole or probation or supervision, any of those kinds of things. The felony conviction with 2 years, the date of conviction is the date on which the plea is entered. So in a lot of cases, you'll find that the plea is entered on, February 16th, but they don't actually get sentenced and then start their sentence until, March 20th. The conviction date is the date that we're concerned with here. And that can get confusing for a lot of folks, but there are some simple ways to look it up. It's usually right there in sort of their final journal entry documents that they will receive upon plea or upon sentencing, and it's spelled out in there. Conveniently, this does not apply to post-judgment diversions. The diversion date, the one that's most concerned there is the ending date of the diversion, not necessarily the date in which you signed the diversion, but talk more about that in a future slide as well. The next step in determining eligibility is that the offenses within that case must be expungible. There are certain crimes for which no expungement can be granted. And, there's the long list, as you can see here, some pretty horrifying things on that list. But the simple way to sort of remember it is these three topics. If someone died, if this is a sex crime, or if the crime involved children, those typically cannot be expunged. These are expressly in the statute for expungement that they cannot grant one in these cases. And there's a catch-all for any comparable offense. When you have older statutes may not be titled the same thing, or maybe it's just the elements of the crime are sort of the same. That's sort of that catch-all. And if there's any questions about that, obviously don't hesitate to contact an attorney, give us a call. We can help parse that out and determine if this is an expungible offense or not. The wait period. Each case individually has a statutorily assigned wait period. Excuse me. This wait period, or cool down period, as I often call it, begins on the date of the final discharge. So in the case of a probation case, where maybe the person didn't go to prison or didn't serve any jail time, but they were put on probation for a period of time. The court will then sign an order terminating that probation, and that is your date of termination. And so it's the date the sentence was satisfied. If you complete your parole, you satisfied your sentence. If you complete your time in prison, and there's no post-conviction or post-release supervision period, no extra time on parole or probation after your time is served, then it will be that date that you get out of jail. There's some in each each case is going to have its own wait period, and we're going to get into each one individually here. Um, the first one is a 1 year wait period. I have never done one of these. I've never seen it, although it is available for folks. I've just never seen an applicant who qualifies for this. And it's for if you are convicted or granted a diversion for prostitution and you can prove that you acted under the coercion. I would imagine that's probably pretty hard to prove up, although maybe not. Again, I've never worked a case where this exception has applied. I've had a lot of folks who think the exception applies, um, but it only applies if it was a conviction or diversion for prostitution. If you committed a theft and you try to come in, I've had people try to come in under this who are saying, "Hey, I committed a theft, but I was a prostitute under coercion of force or threat of force." And unfortunately, it's not for theft. It's only for those convictions of prostitution. Um, the more common one is the 3 year wait period. This applies to traffic infractions, all your basic misdemeanors, very low grade felonies from a very long time ago. That's where you're getting into the D and E. Um, as you can see in the last two bullet points there, or the last three bullet points here, severity levels are no longer classified on an alphabetical or alphabet letters. They're now done by numbers. So if you're seeing the D and the E's and the A's and the B's and the C's for felonies, those are typically very, very old convictions. Now we use severity levels, but as you can see, 10 being the lowest severity up to 1 being the highest severity, these lower end felonies have the 3 year wait period. And it's the most common one. Typically, when you're getting into some of those higher level felonies, when you're getting into the 5 year wait periods, there's other things that might be a bar, like registration requirements and things of that nature. Is an exception though for the 3 year wait period that we've done a lot of work at KLS with, and that's the specialty court exceptions. There are a lot of specialty courts around Kansas. There's behavioral health courts, there's drug courts, there's veterans courts, there's DUI courts that are starting to kind of get off the ground in some places that aren't specifically drug addiction courts. They more focus on the sort of alcohol addiction. Um, and these are popping up around the state. They're great programs. They focus on sobriety, sort of a holistic approach to dealing with substance abuse issues. And if you specifically, if you complete one of these programs successfully, you graduate, the wait period of 3 years will be waived. And in Kansas, your typical time period in one of these programs is about 18 months. And so you've got the record for 18 months, and then as soon as you graduate from that program, you're eligible for expungement. And you can actually be awarded the expungement on the date of graduation. So a lot of the courts in the areas, and a lot of areas will do sort of a joint graduation ceremony plus the judge signing off on all of the expungements. And it's really great because you're coming out of that sobriety, you're starting into that lifestyle of sobriety with a clean slate. And I think it makes things a little easier for folks to get back integrated into society. The 5 year wait period, obviously that list is long. We're not going to walk through all of them. But you'll notice at the very bottom, DUI first conviction. When I was a prosecutor, one of my specialties was DUIs. Your first conviction is a 5 year wait period. Further convictions, the wait period ramps up.
Andy, we did have a
Yeah,
question in the chat.
sure. Yeah.
Does it cost the person who opts to go to drug behavioral or veterans court?
Does it cost?
Mm-hmm.
We will talk about costs a little bit, but typically, I have found in my experience anyway, the drug court judges are very happy to waive those fines, or not those fines, those application fees or filing fees for expungement. after graduation from a specialty court program. It depends on the judge, but there are also other ways around that, and we'll talk about those a little bit later in the presentation. It's a good question, though. So as I was saying, the subsequent second or subsequent DUIs are going to have a longer wait period. They're 10 years. And I think if you're getting beyond third conviction for DUI, you might have problems in some of those other areas that we're going to talk about, like behavior and circumstances and public welfare. There is a weird quirk of Kansas law when it comes to DUIs. If you committed the DUI between July 1st, 2014 and July 1st, 2015, it's a 7-year wait. And without getting into all the really crazy nuances of why that is, it's just a matter of the statute changed in a really strange way. And when I say the statute for DUI changed in a really strange way for that 1 year period. Um, and whether or not that counts as a first or a second, it was constant battle as a prosecutor trying to figure that out. But suffice it to say, if you think that might have been between that July 1, 2014 and July 1, 2015, I would encourage you to at least meet with an attorney or, again, give us a call to try to understand whether or not that's one of those ones that's got a 7 year rather than a 10-year wait. And again, that applies only to second or subsequent. First years are 5 year across the board. Another big one that we find tends to uh, trip people up is outstanding fines, fees, and restitution. Now, this is not specifically in the statute that says you must have all your fines and fees paid. Um, but it's sort of been created by the judges and the prosecutors. And I know I had one case since 2023 when I joined KLS that was expunged while there was an outstanding balance. Very specific set of circumstances that would not apply to most people. Um, the biggest issue with it is for cases where there isn't any jail time actually, assigned. There's no probation time, none of that. The clock starts when you pay it all off. Um, if you did have probation or some jail time, the outstanding balance doesn't affect that wait period because of the way the statute is worded. Um, I think the issue that most people run into, though, is that the balance does have to be zero before the court is going to grant it. Again, like I said, I've had one case out of the dozens, maybe more than dozens, hundreds. I can't say for sure how many of them I've done off the top of my head, but I can think of only one instance where there was a remaining balance, and the judge granted the expungement in spite of that remaining balance. So when you're talking about outstanding fines and fees, there are some interesting quirks of law for older cases where you can get some of that waived, but it's very, very unusual to get fines, fees, and restitutions waived. The court takes them very seriously. They kind of consider it part and parcel to the goals of criminal justice, which is that fines, fees, and restitution are part of the sentence, and therefore need to be paid off before a case is eligible for expungement. Here's some of those soft ones. The circumstances and behavior warrant an expungement. So what are we talking about when we say circumstances and behavior? Things like employment, volunteer services, engagement with the community, whether that's faith-based or maybe you coach a soccer team or you volunteer for Meals on Wheels. Sobriety can be a big component in there, especially if we're talking about DUIs or drug cases. Probably the biggest one is staying out of trouble with law enforcement. I haven't seen it actually cause too much of a problem, but this can even include traffic tickets, especially if we're talking about things like driving while suspended, or no insurance, no proof of insurance, when you get pulled over. Those are misdemeanor offenses under the law. And so they can put a wrench in trying to get an expungement on something if you have convictions for those things. I think the biggest thing here, and it's in caps at the bottom for a reason, is that this is where you're showcasing the positive facts. What has changed about this person since the conviction itself versus today? Whenever I'm walking a client through preparing for the hearing, which we'll talk about more as well in a few more slides, I always want to tell them we're here to focus on what you're doing now and compare it to what was happening in the past. We're not here to necessarily relitigate whether or not you were guilty of this case or what what defenses you might have or things like that. We're here to talk about how your life is so different from what it was back then. And I think the change in behavior and circumstances to warrant an expungement um, is kind of where the attorney is going to earn their keep. You're taking facts and trying to advocate for your client to show that this is a change and it is a substantial one that does what? Consistent with the public welfare. Again, this is a soft sort of inquiry. This is a subjective thing. There are no strict bullet points that need to be checked off as you're going through an expungement. The interesting thing about this is that it asks the judge to take the point of view of the community as a whole. Um, some of the things that we have seen and I have seen that sort of cut against this are going to be things like pending misdemeanor cases. If you're here on a felony drug case and you've got a pending, assault misdemeanor in a municipal court, that's going to give the court some pause. They're going to say, well, maybe your behavior and circumstances has changed. We're not dealing with issues of addiction or behavioral health issues. But here we have, a theft case, or here we have an assault case, most recently in a municipal court. And while not an actual statutory bar, part of the thing the judge is asking themselves is should this case history be removed, and is that consistent with the public welfare? If you have very long criminal histories, this can be probably the biggest hurdle for a lot of folks even if they're otherwise eligible. If they've got every year since the year they turned 18, here's a conviction, here's a conviction, here's a conviction, that can be difficult for a judge to overcome. We don't want people focusing so much on the past because the future is unknown. But unfortunately, in today's society, we do look to the past to sort of determine if the outcome is going to be a certain way. And it's sort of the same thing as grades or applying for a job. Have you been consistently good at something in the past and shown that you can be academically successful? Then school looks at your grades. Same kind of thing here. Another one that I want to point and direct your attention to is that if the underlying case has severe or very unusual facts, while in terms of pleading things down, I have had instances where someone is charged with, mistreatment of a dependent adult, or, child endangerment and those sorts of things. And then they plead those things down to things that might be expungible. The judge has access to all of that case history. And so you need to be prepared to answer questions about the underlying, maybe severe nature of the facts or the unusual or strange set of facts and circumstances that went into the underlying conviction. These two components, circumstances and behavior, and the consistency with public welfare, they go together because again, this is where the judge is having their discretion. Of course, expungement is a discretionary act by the court, so this helps guide that discretion. But it's kind of where the lawyer earns their keep. This comes up a lot these days. There's a felony firearm requirement, and at the very bottom of the expungement statute at this point, it kind of is just sort of shoehorned in there. And if you're seeking the expungement of a felony, the judge has to make a specific finding that your possession or your client's possession, I should say, of a firearm is not likely to pose a threat to the safety of the public. This can be very easy hurdle to get over if you're talking about, maybe a drug conviction. But if you start talking about some of those person crimes where there's a direct and identifiable victim, this can be a little bit harder. And I think it can be especially hard in cases where maybe there was a violation of a protection order, or a domestic battery type conviction. It's usually relatively easy, like I said, in those cases where there's not a direct victim, not someone I can point to and say, Sally was the victim of this case. If you're talking about like theft from a Walmart, maybe a little easier to prove this particular element. But if you have those person crimes, it can be difficult. It is especially difficult, again, the bottom point on this slide, if the underlying case involved a firearm. If you have an aggravated robbery, which is a robbery of a direct person with an identifiable victim, and you used a firearm in the commission of that offense, this is a very high hurdle to clear. It is possible, but it just adds another component to the requirements. Why is this important? Well, the 10th Circuit decision that applies to Kansas expungement statutes talks about folks wanting to get their rights to own a firearm back. Um, in Kansas, there is a portion of the statute that says upon granting of an expungement, a person's Second Amendment rights shall be fully restored and all these sorts of things. Federal government doesn't really agree with that. The issue in the case was Wyoming ex rel. Crank versus United States. And basically, in order to get your gun rights back at a federal level, you've got to meet certain definitions of what an expungement is. Now, in Kansas, the record is not destroyed. The record is sealed. It can be resurrected. It is still available for certain folks to see. And only states in the United States that have record destruction expungement qualify as expungements at the federal level. And so while you may be state level allowed to have your firearm, the federal government may not be granting you that right back. So again, it's only states where the record is destroyed, not sealed, where that federal ban on you owning a firearm can be taken away. This is kind of a word heavy slide. But at the end of the day, it's sort of spelling out what they're talking about here, which is if you've got a conviction for domestic violence or a violation of a protection order or a conviction for stalking, those kinds of things, you've got to have record destruction and pursuant to Crank v. United States out of the state of Wyoming. So there's arrest only records are a little different than convictions. Any person who's been arrested in the state may petition the court for an expungement. Under one of just four categories: a mistaken identity, if a judge gets to what's called a preliminary hearing and finds that there was no probable cause for arrest, if a jury finds you not guilty or a judge finds you not guilty. Or the fourth one, which is the one that I typically use the most, is that expungement is in the best interest of justice and the charges have been dismissed or not likely to have been filed or be filed. This comes up the most in sort of plea negotiations. You may hear about folks saying, well, I had 5 cases, I pled to 2, they dismissed the other 3. That's where this comes in. Those other 3 that were dismissed, the charges were dismissed pursuant to a plea agreement, and they're not likely to be refiled. The nice thing about an arrest only record expungement is that there's not a filing fee associated there. If you qualify for an arrest record expungement, the statute waives the filing fee. I don't know if that's been fixed yet, because when I read through it, it looks to me like it was mostly because there was a mistake in the drafting of the legislation, that all arrest record expungements should not be, strictly speaking, cost free. It looks to me like the intent was that the only ones that are cost free is it should be mistaken identity, no probable cause, and being found not guilty. Whereas I think the intent may have been that those that were dismissed for a plea agreement, you still got to pay for the expungement because you did end up with a guilty finding. I don't know if that's true or not. It's just my speculation. It's just when you're reading the statute, it requires some pretty hefty reading to get to the point where there is a statutory waiver for the fines or for the fees for filing. But as it stands right now, which is great for a lot of folks, there's no cost. So an eligibility sort of summary page, and I think, Kayla, correct me if I'm wrong, these slides will be made available to folks. If you need me to send them to you, I certainly can, but if Joy or Nick has already sent them, then these will be available for you guys. And this is just kind of a summary of what we talked about so far.
Yeah, I can get those added once we upload the video.
Great, 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 great. Thank you. So just kind of a summary page. This could be your go-to if you decide to download the slides of what is required for a state level expungement in Kansas. Which brings us to municipal cases. Municipal courts are actually where I did most of my practice, and it is actually the place that most people touch the criminal justice system. Felonies and misdemeanors at the state level are much less common than misdemeanors at the state court level. Similar requirements, all those same sorts of things, behavior and circumstances, and public welfare, and those kinds of things are what the municipal judge will have to consider. There's only one thing in the municipal courts statutes that can't be expunged, and that's driving a commercial motor vehicle under the influence. I guess they suppose, and I kind of agree, if you're driving a semi or a school bus or something while intoxicated, maybe that's something we'd want the public to keep knowing about. Um, Most cities have a filing fee associated. I know KCK, where I used to practice, is very liberal in their application of waivers for those filing fees. They usually run between $50 and $200 in total. The interesting thing is some cities in Kansas sort of break that down. And this is the application fee of $50, and then upon the grant of the expungement, you got to pay another 150 or 75 and 75, or however they get to their total that they want paid for their expungement services or their expungement, I guess, granting the expungement. They're not standardized in any way. There's nothing in the state level statutes that would command cities to charge so much or so little. Poverty waivers can still apply in these situations, although it's going to be very hit or miss between the judges of the various cities about whether or not they're granting those. Again, where I used to practice and where I was doing my prosecution in Kansas City, Kansas, very liberal and generous with granting the poverty waivers. Although, some state courts, that might not necessarily be the case, but throughout the Johnson County, for example, a lot of the jurisdictions in there, you can file one, but there's really no chance in heck that you're going to get a poverty waiver granted. So again, it's case by case, and you'll notice at the top here, throughout everything has had a little KSA at the very top, and here the statute is a little different. Chapter 12 in the Kansas statutes is for cities, and that's the statute citation here is 4516 in chapter 12. Any questions so far? Ooh, I'm doing my job then. Great. Um, So how do we get through all of this? Well, we file an expungement. It is a petition that is filed in the state court or again in municipal court, and it's $195, and I think 25 cents is the electronic filing cost. So the total will be about $195.25 per case at the state level. And when I say per case, that doesn't mean per individual. That means per case. If you have 4 case numbers, then you're going to be paying $195.25 for each case. And again, just to note, municipal courts are going to have a different fines or fee schedule. And as we mentioned, the arrest records, there's no filing fee as long as it's one of those 4 categories. So the petition is filed in the court in which the conviction was taken. So, for example, if you've got 2 cases, one in Riley County, one in Johnson County, both are drug convictions, doesn't matter that they were related in some way. One could be a drug and one could be a domestic. Um, you have to file on each case in each court where the conviction was taken. So, in the example that's provided here, there will be one petition filed in Riley County and one petition filed in Johnson County, both accompanied by a $195 filing fee. Sometimes the courts have other options for how you might file. Typically, we are required to file by what's called the eFlex filing system. Although, if you are an individual doing it by yourself, you're not an attorney, there can be some other options besides literally walking it into the courthouse. Some do allow fax filing or email filing. Very unusual for email filing. Typically, the courts want you to be there in person. These are petitions, they're formal legal documents. I guess the court wants a little bit of buy-in, physical buy-in for that. If you're an attorney and you're filing, you just use the e-flex system.
There's one question in the chat.
Sure. Yeah.
It says, if one case has three felonies, would it still only cost 195?
Yes. So to make that a little more clear, if there's a case number, it doesn't matter how many counts are within that case number. If you have I'll use one from the example here. If you have a 2010 CR 123 and there are 16 counts in there for, maybe typically you're going to see that like with a credit card fraud case. Um, and you've got 16 counts in that one case, that 2010 CR 123 requires one filing fee. The Johnson County case may have only one conviction in it. The 2011 CR 1223, that has one filing fee. So if you have multiple case numbers, that's when you're getting the multiple case filing fees. Good question. Oops, did I skip one? Nope. So the hearing, the fun part, or maybe not so fun part, depending on how the case has gone. Some courts do have a specific day set aside. I want to say Geary County used to be one that did this, where it's every Thursday at 1 o'clock is our expungement docket courts. Others, they just have a specific, we said all these simple hearings on this day, you may be mixed in with other kinds of hearings. Um, and some will be scheduled based on the specific judge that's hearing those cases. Typically, when you're talking about an expungement hearing, the case is going to get called by case number and name. The court will ask the state if they object. The state or judge may have questions for the defendant. If you're an attorney on this call and listening in, I recommend asking the judge if you can present the testimony or present the evidence supporting the petition by proffer. And that is where the lawyer sort of stands up and says, wow, he's a great person and she's done so much for her community since then, and he's enjoying his sobriety, or she's, working at a faith-based organization delivering meals to disabled folks, or whatever. And then the judge can ask the person to swear or affirm that what they just heard was correct. On the other hand, some judges will prefer that the defendant be the one, or the petitioner, the person asking for the expungement, be the one to testify. And again, this is where the lawyer earns their keep. All right, put my client on the stand and ask them questions. Usually the focus on these hearings is going to be about the circumstances and behavior and the public welfare components. Don't really usually dig too far into the fines and fees, or the statutory wait times or eligibility questions at that point. The hearings are usually uncontested, especially if the state is going to agree. If the state doesn't have any questions, they're not going to ask any questions. And then the judge will either take the matter under advisement. I've only had that happen in one or two cases. Usually the decision happens right then and there, where the judge will say, I'm granting the expungement or I'm declining the expungement. Which brings us to the resolution. If the expungement is not granted, so if the judge denies the petition for expungement, then they have to give a reason. This is a determination by a court. There's got to be reasons as to why it's making its decision. They will have to make it clear on what grounds they're not granting it. Oh, I don't think that the behavior and circumstances is warranted because there was a conviction 3 years ago. Or it looks to me like you've committed a lot of crimes with a gun, and I don't think it would be good for you to have one. Um, the judge can also, the way the judge makes the decision can also inform when's the next time I can take a bite at this apple. The judge's decision can inform you about where to buttress the case the next time you make a petition, whether it's the time frame, like, well, we've got a few cases more recently and I'd like to give it a little more time to cool off, or hey, I can't give you the expungement because you're still on probation in this other case, or you're on parole in another state, or they can give you sort of a pathway to get to the expungement level the next time you try. So what happens with the judge grants it? Well, like we kind of talked about at the beginning, this is going to seal it from the view of the public. Think landlords, think your typical employers, think your typical sort of schooling situations, or maybe trying to get some funding for schooling. It can take up to 5 weeks, though, for the courts, the KBI, and the FBI to scrub all those databases. I typically tell my clients after an expungement has been granted to give it 4 to 6 weeks um, before it's going to totally not show up on when someone runs a background check. I think the important thing to remember, though, is that when an expungement is granted, the court will give you or will sign an order, I should say, of expungement. And that order is sort of your ace in the hole. If you are applying for something after you've gotten your expungement, but maybe before these databases have caught up to that, certainly, if someone says, "Hey, we found this on your background, like we got to talk about it." I have this signed paper by a judge right here says you must not consider this against me. That the order is effective the day it is signed. Whether it's filtered through all the databases is not your problem. The judge has already said that you are to be considered as if you have not been charged, arrested, or convicted of this crime. And it can't be considered against you, except for in required disclosures. There's a whole huge list of folks who can still see the convictions or who are entitled to see the convictions, I should say. Not necessarily that they can just type your name in and oop, there it is. Um, there there's a big list though of folks who can still get access to them and to whom you are still required to disclose this. I'm not going to go through the whole thing, but some ones that probably are the most important is the Kansas Department of Aging and Disability Services. If you are applying for a job in a licensed facility, you need to disclose that this conviction exists, but you still have your ace in the hole, which is the order from the judge. This was expunged, but you still have to disclose it because KDADs can still see it. The practice of law, if you're applying to the Supreme Court for a license to be an attorney, they can still pull this up. Obviously, they're judges. Another one that I like to remind folks of is if you get convicted for a subsequent offense, your expunged convictions, though sealed, can still be used for sentence enhancement, can be considered as prior convictions, and do need to be disclosed. Um, Most of the other ones, like I said, there's a ton of them, and they're very, very specific. They are very, very specific. If you have questions about that, the list is in the statute. But you could certainly give us a call and ask if, is this a situation where I need to disclose? The other big one is probably CDL applications. A lot of folks who may be struggling or have struggled in the past with being convicted, CDL being an over the road trucker is a great way to sort of get back into gainful compensation or gainful work.
One question in the chat.
Yeah. Mhm.
It says, if the people who saw it and have already made a decision um, based on the record that should have been expunged, do they have any recourse?
I'll give you the lawyer answer. That depends. We would need to suss out some more of those facts. Was the expungement had before the denial? If so, I suppose there could be some recourse. You could maybe potentially file some kind of a lawsuit about it. There's nothing in the statutes that specifically gives you a right, a cause of action, the right to sue over it. Typically, when you're presenting these sorts of situations, it's because the expungement has already happened maybe a few weeks before, hasn't filtered through the database. And, again, the other part of that is there has to be a disclosure. If this is one of the folks on the list that is required for the disclosure and you didn't make the disclosure, I don't think you have anything that you can do about that. But if it is not one of those types of people that's on the list of required disclosures and they still held it against you, despite the fact that you had an expungement prior to the application, I think you may have something that, yeah, you could take some action on. Again, I don't know. I have not had that situation, and I think we probably would need a little more facts before we could give a definitive answer. But certainly, if you got the expungement prior to you applying, and they are not on the list of required disclosures, and they still used it against you despite being advised, hey, here's the judge's signature that says this is expunged and you're not allowed to, then maybe we can talk. But for the most part, the timelines and the facts are very, very important in that inquiry. What's the end result? Like we were just talking about right here. If all the felonies are expunged, then you are no longer considered a felon, period. Full stop. This opens doors in housing. This opens doors for jobs, makes getting certain kinds of educational funding a lot easier, or even getting into certain educational institutions a lot easier. Um, Again, it's about the sealing, though. It's not about the destruction of the records, and there are still going to be those instances where individuals or organizations, I shouldn't say organizations, agencies probably is a better way to put it, because they would be state actors typically, can still see the convictions and can still consider the convictions against you. Um, with that, kind of brings us to the end. Are there any questions, comments, concerns? I do love colorful limericks as well. Think I see any hands. Oh, there's a chat situation going on. Let's see. Can I see the chat?
I think we got to most of the questions in the chat.
Yeah. One thing I did notice that I may have kind of glossed over was drug registration. If you're on the drug offender registry, there is a procedure by which you can get off early, and basically it's sort of the same kinds of qualifications as an expungement. They can be filed together at the same time, so your petition for your expungement and your petition for your early termination of drug registry can come together and on the same petition. And basically, I'm not on probation anymore. I have registered for 5 years, and I can show with evidence treatment or rehabilitation sufficient to warrant an expungement. And the important part of that is going to be that treatment component. If you can show sobriety, if you can show I completed an inpatient, outpatient, going to NA or AA meetings, um, getting off the registry a little early for drug only. That's the important thing to remember. The only one you can terminate early for registration is a drug offender registry. The violent and sex offender registry, there is no early termination.
I have a secondary question to that, Andy. I
Sure.
kind of talked to you about this before the meeting started, but for federal crimes, if it's a federal drug offense and you're required to be on the registry as a drug offender, is that the same avenue as being convicted under state and getting off of the registry, or is that different?
No, unfortunately, so if you're on the federal registration, the state can't go above that. So if the
Hmm.
federal conviction is requiring a drug registration, um, the Kansas Offender Registration Act, or CORA, that avenue for getting off the registration early is for CORA-based offenses, not the federal registration offenses. So if you get a federal conviction that is requiring you to register on a federal level, unfortunately, not really an avenue for that. Good question, though. There's a lot of push and pull with the state and the feds, especially these days, in terms of criminal record retention and that kind of a thing.
Hey Andy, can I ask a question? I'm
Sure.
I'm not trying to be contrary, but so my ears hear like this expungement is like sealing the record for like jobs that are like over here but never over here and more for like rental stuff and your credit rating kind of
Mhm.
background check, right? So if somebody wants to do like a hard background check, they're going to see this regardless of whether or not it's sealed. Yes?
So I don't think so. The
Okay.
only folks who are entitled, again, once the record is sealed, the only folks who are entitled to see such a record are the ones who are specifically on the list. If you're talking
Of on the list that you need to tell them, essentially.
typically, yes.
Okay. Okay.
One of the ones that doesn't match up is prosecutors and law enforcement officers. I mean, we all enjoy a Fifth Amendment right against self-incrimination. So you can't be compelled to give that testimony against yourself of like, hey, I had a conviction 40 years ago for gun crime, right?
Right. Hmm.
Um, but the prosecutor or the law enforcement officer they have access to the criminal databases. I mean, of course,
Right.
they stand up and swear I won't use it for illicit purposes. And if they're not using it
Right.
for illicit purposes, then certainly they can still see the conviction, but you're not required to actively tell them. So in some ways, there are actually two lists in the statute. The first list is these are the folks to whom which you must disclose the conviction. And that's going to be the KDADs, that's going to be the Kansas
Right.
Lottery and those people. And then the second list is these are the people who can still see the conviction if they ask for it, right?
Okay. So
Um,
it wouldn't be a case of like someone getting pulled over and the cop pulling their record and they can see, oh, you had a felony in 2016.
right, exactly,
They
exactly.
can or cannot see that.
That's the little fact dependent, but if it's so, for example, if you get pulled over in Wyandotte County and your
Yeah.
felony was in Wyandotte County,
Yeah.
the police record, the police reports that were associated with that,
Yeah.
not necessarily deleted.
So it's not really it's expungement on paper for like apartments and credit checks and things like that. But when it comes to law enforcement, they're going to be able to see that probably.
Right. Again, what
Okay.
they're going to be able to see is not the conviction, though.
Right.
What they'll be able to see is that there was a report in 2020, 2012 about, a firearm being discharged into a vehicle, and you were
Sure.
associated with that report.
Okay. I just
Yeah,
wanted clarification around that.
sure.
I have a lot
Absolutely.
of people that have felonies, and yeah, it limits their ability to move,
It's oh, for
through.
sure. Absolutely. When it comes to law enforcement records, even when you get into the Kansas Open Meetings Act and the Kansas Open Records Act, there are all kinds of exceptions for law enforcement records. And I will say that expungement is really no different. Again, the police department is entitled to keep its own records. It is entitled to have its reports, but the officers are not going to have access to the conviction. They're not going to have access to the charging documents or the sort of ending documents that closed the case, at the end. What was your resolution to the case, expungement or no? They're going to still have access to their police reports, though.
Right.
Yeah.
But they can request those if they feel the need to do so.
The individual to whom the reports
Like
are
they can
directed.
request the like list of charges. Like say they pull someone over and they feel like it's relevant to request like what happened during that charge. Am I just like running down a hill right now that's
Yeah,
irrelevant?
a little bit.
Okay.
Like you're talking about, so I was a prosecutor for many years before joining Kansas Legal Services. If you've got a situation where a police officer has the kind of time to dig that far down, how are you on the side of the road for a day and a half while you're sending a formal work? Because the thing about that second list of the people who are entitled to see it, they have to make a formal request to the court to see those charging documents,
Okay.
to see those documents. It's
I
it's
won't
not
take up any more of your time.
no,
I
you're fine.
appreciate it.
It's totally understandable.
Thank
But if you're
you.
talking about the sort of system that they have where they're typing in names to run a records check in the patrol car, those are not accessing the court's information.
No, yeah, I get that part.
Accessing
I just mean like say they throw you in jail and then they think, well, you had previous like stuff going on. We can look that up now and sort of connect it to this thing or whatever. But it's irrelevant. I can like rabbit hole on the computer later.
Sure, sure. And feel free to shoot me an email if you have deeper questions. Absolutely happy to answer them. Again, I was technically a law enforcement officer for a good portion of my career before joining Kansas Legal Services as a prosecutor. That's what you are. And so I'm happy to answer those kinds of questions and maybe use a little bit of my experience to help your folks maybe understand where their position is. Absolutely happy to help. Any other questions?
We had two more in the chat. We've got about
Sure.
6 minutes left.
Yeah.
Um, it says, what about DCF seeing the expungements for a proposed guardian for a K2K case?
Well, so I guess there might be two questions in there that are actually being asked, but not being directly asked. Expungement does not apply to DCFS records. If the Department of Children and Family Services has, open investigations, whether or not those were found to be substantiated, unsubstantiated, pursued upon, or any of those things, that is not expungement. Expungement is for criminal convictions only. In terms of the lists of people who can receive the information and to whom you must disclose it, I don't see DCFS on that list. I see the Kansas Department of Aging and Disability Services for, applying for a job in those situations. Um, I think that might be a tactical sort of on the ground decision. Is this something we want to be honest about? And then, we're honest about it, like, hey, yes, there was a conviction, but also that's the other thing people often forget is you will have a paper physical copy that you can have to show the court this was expunged. Might be a tactical type decision about whether or not you disclose that, but there is no requirement in the statute that when you're applying for a guardianship that you disclose that. Although I will say, small caveat, there's a huge change to the guardianship law in Kansas. That may have changed. I'm not an expert on guardianship, but I can tell you in the expungement statute, there is no requirement to disclose in that case.
Great question. Last question in the chat, and this goes back to the filing fee. Says,
Sure.
just to clarify, if an individual has 5 cases and per the plea agreement, they pleaded 2 of the cases, 3 got dismissed, they only need to pay the filing fee for the 2 cases and file the arrest record expungement as well.
That is correct. So if again, there's some other attorneys on the call. You guys may all be familiar with the Kansas eFlex system. There's a little radio button when you're filing an expungement that says, "How are you paying for this?" And one of those radio buttons says statutory waiver. And so when you're filing the arrest record expungement petitions, you select that radio button that is, this is a statutory waiver. The first 2 that were the convictions, that one you will have to say, all right, I'm using this card to pay those filing fees. Or excuse me, when you appear in court to file your petition, hand them a check for the $195 times 2. I'm terrible at math. I don't know what that ends up being, to 390 bucks or something like that. Terrible at math. Don't quote me on that, but it's $195 per case. Yes, if you have 2 convictions, that's 2 filing fees for $195. The 3 cases that were dismissed, no filing fee. Which I guess just one last little thing, really fast. Poverty waivers, poverty affidavits apply across the board in these situations. If your client has no income, they probably aren't going to end up paying a filing fee, at least at the state level. Municipalities, like I said, it's hit or miss. You never know. It depends on the judge. But for most of the counties, I will say, if you have a poverty affidavit with $0 in income, I have not had a situation where a judge is not granting that poverty waiver, so you don't pay any filing fees. Anybody else?
I think that's all the questions in the chat.
Great.
This was a very great presentation. Andy, thank you so much for answering all the questions.
Well,
And this was such a good webinar. We will have this uploaded to our website. We try to have them up there within a week. We try really hard. So if you want to share this with a colleague or want to rewatch it, we'll have it up there for you along with previous KLS webinars. And with that, I hope everyone has a great rest of your day. Again, thank you so much, Andy.
Thank you, guys. I really appreciate the opportunity. Let us know if you have questions. We're happy to help.
See you guys. Thank you.